Good afternoon. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today we will discuss with the Labor Attorney Jung Bong-soo about the Labor Standard Act Article 28, which is the application for remedy of unfair dismissal and related acts. So could you define about this Article 28, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Thank you for asking about some application process for the unfair dismissal. I mean application for remedy from unfair dismissal. So according to the Article 28 of the Labor Standard Act, when employee was dismissed unfairly, then employee can take some remedy claim through the Labor Commission. So this is a very important article because Labor Commission provides such a remedy the process. Also, when their decision in the Labor Commission is very strict, also employees should follow their decision. So also this article shows how to take the remedy application. Also, second paragraph it added that when employee was dismissed within 90 days or within 3 months, employee should take legal action, or not they cannot apply anymore. So within 90 days they should apply for remedy from unfair dismissal. Yeah,
I see. So if the employee do not take an action within that period, everything will be rejected. There's no right for him to claim. So do you remember any exceptional, memorable cases where you had to apply to this Article 28?
Yes, I have handled so many this kind of some disciplinary action cases. So sometimes I represent the corporate client, or sometimes I represent workers. So according to the situation required, I mean at the sometimes most cases I win, but also some cases I cannot win. Then I just guide them, please do not take some legal action, just try to get some settlement, or I try to find best solution for our client. So this the remedy application for unfair termination is a very strict rule in Korea. So as a labor attorney, we always represent the client, sometimes employer or sometimes company. So in so there are certain function. I mean this remedy process, judges there make a decision about whether it is unfair dismissal or fair justifiable dismissal. Yeah. Also, they suggest good settlement. So then both parties agreed on the suggestion provided by judges. Then if they accept, it can be a good settlement process. Yeah.
And I understand that unless apart from the other legal dispute which can take more than a year, this in case of this unfair dismissal, the Labor Commission set the date that they will make the conclusion within 3 months. Is that right?
Yeah. So the function of a Labor Commission plays a very important role in solving labor issue. So they provide a very short, the short-term the solution process. That means when they filed this unfair dismissal case, the judgment hearing will be held maybe in 60 days. So in maybe in the judgment hearing, judges make a decision whether it is justifiable dismissal or unfair termination. Then the result, they can know that evening of the judgment hearing date. So also the written verdict will be delivered within 1 month. So in total, it will take only 3 months. So compared to the civil court case, is this the Labor Commission's case is very quickly solved. I mean, it's like normally civil case, it will take 1 year or 2 years, but Labor Commission's case always it takes within the 3 months is maximum as the total period. Also, they can appeal to the National Labor Commission. Also, it will take another 3 months. So, when they depend on this the Labor Commission process, I think it is it has very strong advantage, like economically, time saving. Also, they can use very professional judges working there, because the judges in Labor Commission, they handle only the labor cases, so they are very professional in this field.
I see. And I understand that rather than going through the legal proceeding, it is best to solve this matter in a friendly way, so that they don't become enemies after this event.
So this Labor Commission suggests some peaceful settlement before they always get to certain own decision. So judges always suggest settlement to both parties. Then if both parties agreed, then the judges give some time, so both parties get together and get some settlement. So as a labor attorney, I solved many cases through this settlement cases rather than receiving verdict judgment. So then if I solve the case through some settlement, then even though I cannot, maybe our client cannot be happy 100%, but they at least they maximized or they secured a certain amount of compensation. So this can be a win-win cooperation or a solution.
I see. Thank you very much for your comment.
Okay, thank you for watching. Bye bye.